Welcome to Friday Friends, RI Elder Info's weekly look at the organizations and individuals providing resources for Rhode Island seniors, caregivers, and professionals.
Good morning, everybody. Happy Friday. It is 9 o'clock on Friday, and you are watching me, Deb Burton, Executive Director of RI Elder Info and the host of Friday Friends, where every Friday for the last 6+ years, I've brought you guests and information that you or someone you know needs to know about. So make sure that you hit the like button, the share button, the bells, the whistles, all those social media cues that say, hey, I am following this amazing program, and you should too. Because you know what? Today, we are having a conversation about one of the things that a lot of folks are really hesitant to talk about, but it's actually really important. So again, make sure that you share this out so that we can get uncomfortable conversations started and make them easier. Now, as you all know, we are a 501c3 nonprofit, and we could not do this without the support of our sponsors. So a big thank you to Point 32 Health Foundation, United Healthcare, and a special message from McCarthy Law.
Here at McCarthy Law, we practice in the areas of estate planning, long-term care planning, elder care law, and residential real estate. Our focus is really on providing peace of mind to our clients.
If you're interested in scheduling a consultation with our office, you can feel free to reach out to us at 401-541-5540. You can also reach out via website at www.mccarthylawri.com. You also should check out our social media, both on Facebook, Instagram, and LinkedIn for some helpful tips and tricks.
Hi, Whitney. How are you this morning?
Hi, I'm well. How are you?
Excellent. So I have heard that August is Make a Will Month. And I am really excited to talk to you about this topic because I feel like it's one of those things that we think we know all about. And in reality, I don't think we know even a thimbleful of what we need to know.
Right. And now I'm very excited to be here with you, my first time on. And we're excited at McCarthy Law to be, participating in Make a Will Month. It's very important for people to, get a handle on their estate plan. We like to be able to help people out with that.
Absolutely. I think a lot of times folks kind of assume that a will is just about like, who gets what, and the Hummels go to this person, and my favorite stamp collection goes to that person. But what are some of the other things that people should think about when it comes to a will?
Sure. So that's correct. The will is, a legal document that outlines, who is going to receive your assets when you pass. Some of the other things that, a will contemplates is who is going to be the executor of your estate. So that's who's that person that's going to be responsible for distributing your assets, who's going to be responsible for making sure that, estate tax filings get done, making sure that, beneficiaries are notified of important hearings. Just to back up a little bit, when we are talking about a will, we're also talking about the probate court process. And it's helpful when you have a will because that kind of almost gives instructions for the court on how you'd like things to proceed. Otherwise, you're left up to state court law to dictate that. So it gives you a little bit more control over how things are going to run and also how your assets are going to be dispersed, because we have people that have worked really hard. Their house, bank accounts, what have you, as well as, obviously the stamp collection, right?
Yes. And I feel like sometimes folks are looking at, some of those websites, or they think it's okay that, if I wrote down on the back of a napkin that, my Aunt Edna gets, my thimble collection, that's good enough. Is there like a formal process that once you pass that the executor has to do? Like you mentioned the court. How does the court work when it comes to a will?
Right. So that's a great question, because in Rhode Island, we do have, by statute, we have certain requirements that make a will valid, right? And so one of the things that the court first will do is, if you do have a will, or you think you have a will, the will be submitted to the court, and the judge will review that document. And things that the judge is looking for, first and foremost, is you can't have it be handwritten, so it does need to be typed. That's a really important one. Okay. So something we've run into recently is that some people are doing, ChatGPT is very popular, right? And so ChatGPT sometimes will put just like lines for the person to print out, and then what they're doing is handwriting in certain kind of specific instructions, right? And this is kind of, an interesting topic. We don't know whether that would kind of push the will into the handwritten, column, which would then, what winds up happening is the will would be void. And then all of your wishes, everything that you have in there, the will is void. So what they would be following instead is our statutes, our state court law with respect to the distribution of your assets, right? So anything specific that you had in there, if you veered from kind of, maybe the more common, everything goes to my spouse. Sometimes people disinherit family members, right?
No.
I know, right? Crazy. No, sometimes people, disinherit family members, or, for whatever reason. And, they might wind up being in the line of descent by statute. So that's an interesting one, right? So to go back to the question, it has to be typed. It cannot be handwritten. So if you do have a will like that, you definitely would want to review that. You have to have two witnesses, and the witnesses, again, this is another piece. So sometimes what you wind up seeing are, kind of the last minute will. Because someone is sick or something like that, right? And so the family members are trying their best to get something together for their loved one. And you need to have two witnesses, and those witnesses cannot be a beneficiary that would be inheriting under the will. So it's not necessarily even to say that it can't be that it shouldn't be a family member. It also can't be, say, a friend that you're leaving everything to, right? So you have to be very careful about making sure that those are third-party witnesses. So those are just kind of some of the unique pitfalls that people sometimes accidentally wind up falling into.
And I would guess that if there's something presented that's kind of like the back of the envelope, I, Deb, give everything to my lovely neighbor, and I just kind of scratch something on the back of the envelope and I pass, that there's some real question that the judges have to work out. So I'm glad to hear that there's some protections around what could potentially be elder abuse and fraud. So I'm glad to hear that. What are some of the things that maybe should be a trigger to review what you've put down in your will? You had mentioned that sometimes people, disinherit family members. What are some of the triggers? Is it like divorce, death? What kind of things?
Yep. So you have the right idea. So we definitely, in terms of when are you, updating your estate plan, I mean, it's kind of different than reviewing it. So really that threshold is, when should you be taking a look at, not only your will, but also your powers of attorney. When I talk about estate plan, I kind of talk about that as well, your financial powers of attorney, healthcare powers of attorney. So any type of, major life event. So if there is a birth to start off on like a happy note, right? If someone has a child or a grandchild, you might want to take a look at that language, because it might be, your prior documents might be more restrictive than you necessarily wanted. So you might want to make sure to include that, new person in your life. Same with a marriage, right? And then along that same line, divorce is a really big one. I was in family law prior to doing estate planning here at McCarthy Law now. And so, I know that a big thing that I always encourage all of my clients to do is, after the divorce was finalized, to make sure to review their will and power of attorney to make sure that they've removed their ex-spouse. And sometimes they may still want to keep that spouse on in some type of role if it's an amicable divorce. And it's also equally important to make sure that you are reviewing and reaffirming that you want that person to still be in that position. So either way, whether you want them on or not, you really want to make sure that you're updating after that certain life event. After the death of a loved one, you might want to reevaluate how you're distributing assets. And then the last one, there's so many different life events, but the last really big one is if someone has fallen ill. You also want to make sure to reevaluate at that point, and also really considering long-term care planning needs alongside with that.
You've given me so much to think about. Now, I noticed that you mentioned powers of attorney and executors of the will. If you're the executor of the will, does that mean that before somebody dies that you have the authority to, make their healthcare decisions and make their financial decisions?
That's a great question. And that is something that people commonly think is correct, right? And so it's actually separate documents and separate powers. So a will is, again, it's that legal document that you have had prepared on your behalf, but it doesn't actually come into effect until you're passing, which means that the person that you have appointed as the executor doesn't have those powers in the will until you have passed. And they're dealing with your estate, whatever that may be, whatever's left at the time that you've passed. The powers of attorney, they're very similar powers and responsibilities that someone has, and that's during your lifetime. So a lot of times people will think that if someone is named as the executor, then they also have the same rights and obligations as a financial power of attorney, but that's not true. That would be a separate document that you would want to have drafted, and that would come into play, if someone does not have the ability to handle their own finances, and it might not even necessarily be full incapacity. It might just be that, as the person is aging and getting a bit older, they don't really have the interest, or they don't have the bandwidth, or it may be that it's just, become too overwhelming, whatever the case may be. And it allows someone to step in and either take over if the person wishes, if if that individual wishes, or to work in conjunction with the person too, to help them, right? Because it's a fiduciary responsibility. So you're always acting in that person's best interest. So sometimes it's nice to have like a helper, is what I say. It really is. It can help with filing tax returns, right? Talking to the bank. I know, I would love to have a helper. Yeah. Calling that 1-800 number to get on the phone with health insurance. So it gives that person the authority to, really stand in their shoes and be able to receive that information, and also to provide information as needed. But those, to answer your question, those are separate documents that you would really want to make sure to have in place. And that's at any age. Like, I have those documents in place.
And so I just want to make sure that I'm understanding this right. Your healthcare power of attorney and financial power of attorney are in effect when you're alive.
Correct.
And when you pass, then the executor of your will is the one who is responsible after you have passed away.
Correct.
Got it. Now, for folks who maybe they don't have like a lot of financial assets, is having a will still important?
I think It is, and I'm not alone in that school of thought. Other estate planning practitioners, and honestly, probably if you put into Google, would tell you the same thing. It's important because one, a lot of people think that things are simpler than they are, and very true. And then the second thing is, either way, whether you have a will or not, if you have passed away and you own, when I say property, I mean either real estate or just
A car,
bank account or tangible property, right? I'm talking about, I should say, assets. You have assets in your name alone. You are going to probate court, and you're going through that. Someone on your behalf is going through that probate court process. So if you don't have someone that you've appointed as an executor, then what's going to happen is either a loved one, either a family member or a friend, is going to be still petitioning the court to be named as what's called an administrator of your estate, which is actually the same role as an executor. It's just a different name because that means you died without a will. The nice thing is that you don't have family members fighting over who should be responsible. You don't, or for instance, say you didn't want a family member to be in charge. You wanted, a really good friend of yours. Or say you wanted your spouse, right? You don't have like those individuals dueling the idea is that you've kind of eliminated that, because what you have done is told the court ahead of time who you'd like to be responsible for that.
And that kind of avoids that mom liked you best. Well, you were dad's favorite and all those nonsenses.
Yeah. And especially, your family and friends are already going through a tough time as it is, right? They're sad. And now they have to deal with all of these administrative tasks. Whomever you choose, they just want to see it on a piece of paper, and it's just one less thing that they need to deal with. Because it is what it is. The answer is the answer, So sometimes it's really, I rarely see people who, their feelings are hurt over who was chosen for that role. And then other times you might have someone that feels maybe out of obligation that they need to do it. It just kind of alleviates, I'd like this person to act in that role. The second reason why it's important, to have a will is because it, again, gives you that ability to instruct the court on how you would like your assets to be distributed. So I mentioned before, if you pass away without a will, you don't have a say in who receives those assets or how much, of that asset the person is receiving. It goes according to what's called intestate laws. If you pass away without a will, you've passed away. It's called intestate. And so, for instance, with if you have a spouse and children, 50% goes to your spouse. The other 50% is distributed amongst your children. Whereas you might have wanted 100% to go to your spouse. So the will gives the power to kind of take back those decisions for yourself.
I like the idea of being in control of what happens even after I pass away. I like that idea. Maybe I'm a control freak. I don't know. It just seems like it would just be way easier to do those things. But you've mentioned a lot of different potential scenarios that, if maybe your spouse is not well, or you have an adult child with special needs, like all these different considerations, because there's so many of them, and I've taken up a lot of your time already today. Can people call you and start a conversation, even to figure out whether or not doing a will is or isn't appropriate? Can they reach out to you directly?
Yes, absolutely. Thank you for asking. Could I provide my contact information?
Yeah, please.
Oh, great. Okay. So my email is WAnderson, ANDERSON, and that's at McCarthyLawRI.com, or you can speak with one of our intake coordinators. Our area code is 249-4207. And one of our intake client coordinators, you actually get a free 15-minute phone call with one of them, which is really nice. Usually flesh out a lot of the initial information then, and they can set up a consultation with us. And we are licensed in Rhode Island, Massachusetts, and Connecticut.
Awesome. Whitney, thank you so much for coming on. And I'm going to have yourself or one of your associates come back on to talk about some of these blended family situations, because I feel like there's so much to unpack there.
Mm-hmm.
But we only have so much time today. And I really appreciate you coming on today.
Thank you so much. I had a great time, and it was really nice to meet you as well. It was really, I hope that I'll be back soon.
Absolutely. Thank you.
Take care.
Everybody, in the days of yours, mine, ours, having a will is one of those things that is really important. It also allows you to control who gets what and allows individuals to be informed in what is the way that you would like your wishes honored. So super important. And how cool is it that you get to talk to someone for free for 15 minutes? How often do you get to see that happen? Give them a call. Whitney is super sweet and just really a wonderful person to speak with. So reach out to McCarthy Law. Now, for some of you, if you've been following and you saw Friday Friends last week, or you've been following us on social media, you have been following, right? You know, tomorrow is our big event, our 6th annual Calling All Veterans Day event. It's going to be at the CB Museum Memorial Park in North Kingstown, right by the Daves and Coles Plaza. Opening ceremonies are going to be amazing. It's going to start at 10 o'clock. It only runs until 1. If you are a veteran, a family member of a veteran, if you are a veteran who is a caregiver of a veteran, a veteran of caregiving, any of the above, make sure that you come out tomorrow and check us out. We are really grateful to Atria Senior Living for being one of our presenting sponsors, as well as Janie Palin, who is our lunch sponsor, Brown University Health, the Long-Term Care Ombudsman's Office, and Greenwich Farms. It's going to be one of the largest resource fairs for veterans and caregivers that the state has ever had. So I strongly encourage you, come by and say hi tomorrow. I look forward to seeing you all again next week. In the meantime, be well and be kind.